It's my pleasure. Hi, everyone. I'd like to just confirm with my bailiff, Jess, rather, that everyone is indeed here. I know that Justin came on, but I'd like to double check.
You're good to go, Judge.
Terrific, thank you. Okay, so let's call the case of Marx versus Sonny's Rooftop Bar. My name is Judge McCoy. Scoring judges, please look to the two buttons on the lower left of your screen. We ask that you turn off your audio and video and that those remain off until the trial ends. We also ask that you have your video set to hide all non-video participants. This means that the only people on your screen right now should be the advocates and me. Attorneys, please make your appearances.
Yes, Your Honor. Good afternoon. My name is Jafar Khalfani-Bey. I'm joined today by my off-screen co-counsel, Ms. Sorsha Wild. She'll be assisting me with the technology in today's trial. Today, Your Honor, we represent the plaintiff, we're representing Jessica Marx in today's trial.
Terrific. Defense?
Yes, Your Honor. Good afternoon. My name is Montana Love, and I'm here with my co-counsel, Ms. Kinsey Clark.
Good afternoon, Your Honor.
Together, we represent the defendant in today's proceedings, Sonny's Rooftop Bar.
Okay, thank you so much. Any housekeeping before we get started?
Yes, Your Honor. We'd like to start by invoking Rule 603, which constructively swears in all witnesses.
Okay, that's acceptable to the court. Ms. Love, do you have any issue with that?
No, Your Honor.
Okay.
We'd also like to invoke Rule 615, which constructively sequesters Miss Morgan Levin in this trial.
Ms. Love?
We're fine with that, Your Honor. We'd like to designate our witness, Mr. Sonny Mehta, as our party representative today.
Okay. So Mr. Mehta will remain in the courtroom as the corporate representative, but all other witnesses will be excluded pursuant to Rule 615. That exclusion shall be considered constructive.
Yes, Your Honor. We'd also like to point your attention to an evidentiary ruling, Ruling 11.
Yep. Is this pretrial
yes.
order?
Yes, Your Honor, this is the pretrial order. Specifically, the ruling 11 states that Exhibit 22 is pre-admitted and may be used at any time for any purpose. We do plan on using Exhibit 22 in opening statements.
Okay. Counsel for defense, do you have any issue with that?
No, that's our understanding of it as well.
Okay. Excellent.
Your Honor, we also like to let the court know that we're going to be playing a video, Exhibit 10, in opening statements. We do intend on offering it during our first witness.
Ms. Love?
We would object to that. We may have some issues with that video and may raise some objections at the time. So we'd ask that it not be played during opening statements and rather waited until it is entered into evidence during opposing counsel's case in chief.
Okay.
Have you heard, Your Honor?
You may.
We understand that, Your Honor, but however, opening statements aren't considered evidence. We're able to show the jury things that we intend to offer during trial. One of those things, and we have a good faith basis to believe that we're going to get it into evidence, is that video.
Mm-hmm. I'm going to rule against your request to play the video during opening and request that you lay foundation. And then you can play it during closing, certainly, if it is admitted.
Yes, Your Honor. Lastly, we'd just like to ask your preference for sharing screens. Would you like us to ask permission before doing so, or just simply state that we're doing so for the record?
Just state that you're doing so for the record.
All right. With that, Your Honor, we're ready to go.
Okay. Housekeeping from the defense.
Just one small thing. We'd ask it when Your Honor sustains an objection, would you like for us to move to strike the offending testimony or just assume that it's constructively stricken?
I would ask that you move to strike it, yes.
Yes, Your Honor. And with that, the defense is ready to proceed as well.
Okay. We will now hear opening statements. Everyone should make sure that they are in speaker view. That button is on the upper right hand of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking.
May I proceed, Your Honor?
You may.
Opposing counsel, members of the jury, may it please the court. Today, you'll learn that it was just common sense that Jessica was drunk. You'll learn today that a 19-year-old was served drink after drink after drink. That she was continuously served drinks despite appearing intoxicated. And that it was just common sense that she was drunk. But let's talk about how we got here. It's spring break 2019. Jessica Marx and her comes to California to visit her best friend, Morgan Levitt. You'll learn today that they partied, explored the city and visited bars. They visited a rooftop bar on March 24th, 2019. You'll learn that Jessica was served wine, beer, shots, and more. So at the end of that night, Jessica tried to get into her car and drive home. But unfortunately, she didn't make it too far. She swerved across a center divider, off the road, and into a ravine. She died. And you'll learn today that the person who served Jessica those drinks, the person who owned that rooftop bar, is the defendant, Sonny Mehta. That's why we're here in court today. Because we're suing the defendant for the wrongful death of Jessica Marx. That means we have to show that the defendant served alcohol to Jessica, a minor, and that when they served Jessica that alcohol, Jessica was obviously intoxicated. And we have to prove that by a preponderance of the evidence, which we'll do today. Now, both sides agree that Jessica was a minor on March 24th. So this case will come down to just one question. Was Jessica obviously intoxicated when the defendant served her alcohol on March 24th? And you'll see that the answer is just common sense. Because we're going to show you exactly how much alcohol Jessica had to drink that. And that's important because we have the autopsy of Jessica here in court today. We know that when Jessica died, she was just 19 years old. That she only was 60 inches tall, 5 feet. And that she only weighed 115 pounds. Keep that in mind when you hear exactly how much alcohol she had to drink that day. Because you'll see that it was just common sense that she was drunk. Now today, I come before you representing Jessica's mother. And when she sent her little girl off into the world, she trusted, hoped that people would have her back. And not that anyone would go above and beyond, but that people would just follow the law. You'll learn today that the defendant didn't use his common sense to save Jessica. So I'll come back before you at the end of today's trial. And I'll ask you to use your common sense to find the truth in today's case. And I'll ask you to find the defendant liable for Jessica's death. Thank you.
Thank you very much, Mr. Khalfani. I want to make sure I'm pronouncing it correctly. Khalfani-Bey, is that how it's pronounced?
That's perfect.
Mr. Khalfani-Bey, thank you very much. Ms. Love, would you like to present opening at this time?
Yes, Your Honor, may I proceed? May it please the court. You can't control what you can't see. Opposing counsel just stood up and told you that on March 24th, 2019, Jessica Marx drove away from Sonny's bar intoxicated. And we agree. We agree that she was underage. We agree that she drank more than she should. We agree that she should not have been driving that night. And we agree that what happened to Jessica Marx was a tragedy. But where we disagree, and what this whole case really comes down to, is whether or not Sonny's bar staff knew any of it. Because you can't control what you can't see. Now, today the plaintiff has the burden of proof. They have to show you that Sonny's bar served a minor even after she was obviously intoxicated, and that, as a result, Ms. Marx died. Today they aren't going to meet that burden because they aren't going to be able to prove that that bar ever knew Ms. Marx was so drunk that staff needed to cut her off. Instead, we're actually going to prove something to you today. because we brought something called an affirmative defense of comparative negligence. And all that really means is that we're going to show you that it was Miss Marx's actions, that she should have realized that she was too drunk, that it was her actions that caused her death, not Sunny's fault. Now, to help you see why the plaintiff is going to fail to meet their burden, and why we are going to meet ours, we're going to ask you to consider 3 questions today. First, can you actually trust the plaintiff's story? Second, what behavior did the staff actually see? And third, how many drinks did Jessica Marx actually have? So first, can you trust the plaintiff's story? You'll learn today that the answer to that question is no. Now, opposing counsel just told you that it was just common sense that Miss Marx was drunk. But you'll learn the plaintiff's one eyewitness who will say that she looked drunk at all that night has told multiple conflicting stories about what happened on the night of the crash. And she even admitted to giving the police the wrong story. You'll learn that she doesn't remember key details about what happened that night. And most importantly, she has no proof that anyone who works for that bar saw anything concerning. Which brings us to that second question. What behavior did staff actually see? You see, the owner and bartender at Sunny's is going to take the stand today and tell you he spoke to Miss Marx multiple times that evening, but he never saw Miss Marx showing signs of dangerous intoxication. Her eyes weren't red or watery. She wasn't stumbling or slurring her speech. By all metrics, she looked fine. And so finally, we get to that third question. How many drinks did Miss Marx actually have? Because today the plaintiff doesn't just have to show you that she drank so much she shouldn't drive. They have to show you that she drank so much that it was obvious to the staff at the bar that she was in trouble. Well, what you'll learn today is that many of the drinks ordered to Miss Marx's table were actually consumed by her friend, the plaintiff's eyewitness, and that Miss Marx had far fewer drinks than the plaintiff will claim. Members of the jury, the staff at Sunny's bar didn't know that Miss Marx was dangerously intoxicated. And you can't control what you can't see. That's why at the end of today's trial, I'm going to get right back up here and ask that you find Sunny's rooftop bar not liable. Thank you.
Okay, thank you so much, Ms. Love. Before the plaintiff calls its first witness, I'm going to ask everyone to switch to gallery view. That button is also on the upper right hand of your screen, same button as you used to go into speaker view. This will allow you to see the attorneys and the witnesses at the same time. Plaintiff, are you ready to call your witness?
Yes, Your Honor. At this time, the plaintiff calls Morgan Livin to the stand. May I proceed, Your Honor?
You may.
Good afternoon.
Good afternoon.
Please introduce yourself to the jury.
I'm Morgan Levin.
How are you involved in today's case?
I was with Jess on March 24th, 2019. That was the night that she died.
How do you know Jess?
She was my best friend. We met back in middle school and we realized we had the same birthday, January 20th. Ever since then, we did everything together. I loved her.
All right, I want to talk about the day Jess died, March 24th. How did that day begin?
Well, Jess was visiting me for spring break and it was her last night in town. So we were going to meet up at her Airbnb and then go to this rooftop bar.
Did you end up meeting up at the Airbnb?
Yes, I went over to her place around 7:30.
Did you and Jessica have anything to drink at the Airbnb?
I had a glass of wine and Jess had one, maybe 2 glasses.
So after that, did you end up going to the bar?
We did. Jess drove us and we got to Sunny's around 9.
How did Jessica appear when you got there?
Well, at first she seemed okay. She was, walking pretty straight and she didn't seem like she was that drunk, but soon after we got there, she started stumbling over her words a little bit more and her eyes started watering.
Did you order any drinks at Sunny's?
We did. It was my turn to pick up the tab, so I paid for them, but we both ordered drinks that night.
All right. Can you tell us exactly which drinks you ordered that evening?
We got a bottle of this red wine. We got 3 White Claws, 2 beers, and 2 of these green tea shots.
How much of that alcohol did Jessica have?
Well, Jess finished almost the entire bottle of wine. I only had a glass of it. She drank all the White Claws. She had one of the beers and one of the shots too.
Did Jessica have anything else that night?
Well, at one point she went inside. We were sitting on the rooftop, but there was a bar indoors. So she went in, and when she came back, she had this mug with her. It had a lime in it and a straw. That was the only drink that I saw her have off that receipt, though.
Ms. Wild, could we get Exhibit 14 up on the screen, please? Now, Ms. Levin, do you recognize this image?
I do. This is a photo that I took. It was at the bar that night, and those are some of the drinks that we had.
Fair and accurate copy?
Yes, it looks like it.
Your Honor, at this time, we offer Exhibit 14.
Without objection, Your Honor.
Okay, Exhibit 14 is received.
Now, that drink there in the back, if we could circle it, Ms. Wild. Ms. Levin, is that the drink that you were referring to?
Yes, that's the drink I saw Jess with after she came outside from the bar.
Do you know if there was alcohol in that drink?
I can't be sure, no.
Thank you, Ms. Wild. So after Jessica had the drinks that evening, how did she appear to you?
Well, as the night went on, she got worse and worse. She started talking a lot more loudly. She was stumbling a little bit more. She was slurring her words. Her eyes were getting more bloodshot. It just seemed like she was getting more and more drunk.
Would you recognize a video of Jessica that evening?
I would.
Do you recognize the image of this video?
I do. This is a video that I took of Jess from that night at the bar.
Your Honor, at this time, we offer Exhibit 10 with the intentions of playing it as a video.
Any objection?
Yes, Your Honor, under Rule 403, may I be heard?
You may be heard.
Your Honor, this video is being used to show how Miss Marks was acting at a time when none of the defendant's representatives were present. We're here today to determine whether Miss Marks was obviously intoxicated to the defendant and not to anyone else. Given that the behavior of an intoxicated person and their level of intoxication changes over the course of an evening, showing a video of what a person looked like at a particular point is simply misleading unless the plaintiff can connect it to evidence the defendant's representatives have an opportunity to see her at that time or at a point very near. We haven't heard that foundation, nor do we believe that based on discovery that it can be laid. Accordingly, under Rule 403, this is inadmissible.
May I be heard, Your Honor?
You may.
In order to meet the large burden of Rule 403, they have to show that it's substantially more prejudicial than probative. Your Honor, we have a video from Jessica that evening. Now, whether or not a person from the Sonny's bar is present in the video isn't relevant to its probative value. Your Honor, we have video of her that night. Maybe the bar people came after and saw her. We don't know, but showing the members of the jury this image and said that showing that she was in this condition that evening is probative. It's far more probative than it is prejudicial, Your Honor. Opposing counsel seems to be more concerned with the weight of the evidence rather than its admissibility, and she can go along with that line of questioning on cross-examination.
May be heard, Your Honor.
You may.
Your Honor, the question in today's case is exclusively.
You may be heard.
Oh, yes, Your Honor. Can you hear me? Yes.
I
okay.
can now. You were breaking up a little bit.
Understood. Okay. Well, the question in today's case is whether or not the representatives of Sonny's bar, the defendant, saw whether or not this individual, Miss Marks, was obviously intoxicated. It doesn't matter whether or not she was intoxicated, but just what they knew about her level of intoxication. This video doesn't go to their knowledge. And in fact, we have a good faith basis to believe that no one from that bar was around when this video was taken. Accordingly, it doesn't offer probative value in today's proceedings. And it is substantially more misleading than it is probative.
Mr. Khalfani-Bey, can you lay foundation as to when this photograph was taken during the course of the evening?
Yes, I can.
Let's have you do that.
All right. Ms. Levin, do you know when did you take this video that evening?
I think I took it around 11. We were at the bar and, you know, Mr. Maida, the owner of the bar, well, he was serving us the entire night. It was around then that I took this video.
Did you ever post this video anywhere?
Jess posted it, I think a little after 11 that night.
Your Honor, at this time, we offer Exhibit 10 into evidence.
Any further objection?
We would maintain that it is still more prejudicial and more misleading than it is probative because it still wasn't connected to explicitly when representatives of Sonny's bar were present to see her actions.
May I be heard, Your Honor?
No need, counsel. I'm ready to rule based on the argument that I've heard, based on the testimony that I've heard. The video will be admitted, and Ms. Love, you may inquire in cross-examination and argue however you see fit.
Yes, Your Honor.
Ms. Wald, if we could play the video.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Now, Ms. Levin, I'm going to show you a list of symptoms in just a moment. I want you to tell me which of these symptoms you saw Jessica exhibiting on that night, all right?
Okay.
You're on a permission to make use of a demonstrative. It's just a list of symptoms.
Yes.
Ms. Levin, did you ever notice Jessica's judgment being impaired that evening?
Yes. Jess decided to drive herself home that night, even after I asked her not to, even after she'd been drinking. So I definitely saw her judgment impaired.
Objection, Your Honor. Specifically to the title of this exhibit that states obvious intoxication. That's counsel is testifying as to that. This witness never stated that these are signs of obvious intoxication. So to object to that header of this exhibit, or rather of this demonstrative, excuse me.
May I be heard, Your Honor?
Sure, briefly.
I'm the one who's presenting this witness with these symptoms. These are symptoms that I listed here, and I'm going to ask this witness if they saw these symptoms. These symptoms that I have listed here are signs of obvious intoxication.
I find that no need. I find the objection well taken, and we're going to constructively redact the title of this demonstrative. I find that the remainder of the demonstrative can be helpful to the jury to orient them to this list of symptoms. should they wish to take notes on it. But we're going to constructively redact the words obvious intoxication, and I will instruct the jury at the close of evidence to disregard any conclusions, any expert, especially any expert witness.
Yes, Your Honor. And I do believe that my second chair will be able to remove the title before closing arguments. All right. Ms. Levin, odor of alcohol. Did you notice any odor on Jessica that evening?
Sure. I mean, she was drinking the entire night, so I definitely smelled it on her.
Incoherence? Was she messing up the way she was speaking?
Yes. As the night went on, it got worse and worse.
What about slurred speech?
She started slurring her words that night the more she drank.
Did she have poor coordination?
Yes. There was one point where we were walking to the bathroom and we were going down this staircase in the bar. I actually saw Jess just stumble. She almost fell down the stairs.
And lost the balance.
Like I said, she couldn't even walk down the stairs.
Thank you, Ms. Wild. Ms. Levin, who served you drinks at the bar?
It was mostly the owner, Sunny Mehta.
Approximately how many times did Mr. Mehta come to your table?
Probably 8 or 10. He was the one that was taking our order, and then he'd come back to serve us the drinks.
Is there any point in time when he told you that he wanted to stop bringing you drinks, you or Jessica drinks?
Not really. There was one point where he sort of looked over at Jess and said, we might need to cut this one off. And then he pointed at her a bit later in the night and he said, I hope this one's not driving.
When did the defendant say this?
Maybe around 10 p.m.
Did the defendant serve you drinks after saying those things?
Yes, we got more rounds and Sunny kept bringing us more drinks.
So what time did you and Jessica leave the bar?
We left right before it was going to close, a little before midnight.
How'd you get home?
I took an Uber.
Did you see Jessica's plan to get home?
Jess decided to drive herself home.
Did you think it was a bad idea for her to drive?
Yes, I told her not to. I asked her to come in the Uber with me. I said, we can get the car the next morning, but Jess said no. She got in the car and just a few minutes in, I saw the car just drive off the road and it crashed. I never saw Jess again.
Thank you for your time. Thank you, Your Honor. I have no further questions.
Thank you. Cross-examination.
Yes, Your Honor. Good afternoon.
Good afternoon.
I want to start by talking about why you're here today.
Okay.
Ma'am, you know that Miss Marx's mother is suing Sunny's rooftop bar, right?
I do.
But you also know that wasn't the only lawsuit she threatened.
That's right.
She actually threatened to sue you.
She did. She said that I should have stopped Jess from drinking and driving.
And after she threatened to sue you, well, then you sat down with her lawyers, right?
Well, Jess's mom didn't end up going through with the lawsuit, but you're right. I did meet with the lawyers before trial.
You don't have any transcript of what happened in that meeting, do you?
No, they were just trying to prepare me before I gave my deposition.
Ma'am, you'd agree that meeting lasted several hours, right?
It lasted a couple hours, that's right.
And after that meeting, well, that's when you sat down to give your deposition for this case, right?
That's right.
Let's talk about how that might have affected your story. Now, you told us just a few moments ago that Jessica Marx had drank a lot that night, right?
She did.
You were taking photos and videos all night long, weren't you?
I was, you're right.
But in all those photos and videos, they only ever show Jessica with 2 drinks that are actually in her hands, right?
That's right. The rest of the drinks were just on the table in front of her.
They don't show whether she was drinking the rest of those drinks, do they?
Not in the photos themselves, no.
They don't show whether you were drinking some of those drinks.
You're right.
Ms. Levin, there's actually some pictures missing from that night. Isn't that right?
There were some pictures that I think I probably deleted because they were blurry. That's right.
Ma'am, you deleted 6 photos off of your phone from that night.
During the 3 hours we were there, you're right.
And you can't prove that those deleted photos don't show you drinking the alcohol instead of Miss Marx.
No, I know that I wasn't, but I don't have the pictures as proof.
Miss Levin, you've had some trouble telling the truth about what happened at the bar that night, haven't you?
I wouldn't say that, no.
Well, Ms. Clark, could we get Exhibit 23 on the screen? And Your Honor, pursuant to Stipulation 21, this is an authentic copy of the police report in this case. And with that authentication, we'd move to enter it into evidence.
May I be heard, Your Honor? Objection, Your Honor, hearsay.
Yes, sustained.
Your Honor, may be heard on that? Your Honor, I don't know if you've spoken.
Very briefly.
Yes, Your Honor. Rule 8038 permits the observation of a public agent making statements pursuant to duty. As a police report, that's exactly what this is. So it is permissible under Rule 8038.
May I be heard, Your Honor?
You may.
Although we have a stipulation that this document is authentic, an authentic police report, we have no stipulation about the accuracy of this document. With no witness here today to testify to its accuracy, this cannot fall under Rule 803, the section that Miss Love mentioned. It's still hearsay, Your Honor. It can't be admissible today.
Your Honor, may be heard.
One more argument, and then I'm going to rule.
That's not quite what 8038 requires. Rule 8038 simply permits the observation of a public agent making statements pursuant to duty, and that's precisely what this is. We've stipulated that's an authentic document written by the police officer who investigated this case. Under Rule 8038, it is admissible.
The problem that I'm having with it is that it has double hearsay in it, multiple layers of hearsay, I should say. And I haven't had a chance to completely scrutinize it for Rule 352. Why don't we take it? Yeah, I'm very reluctant to allow this to allow this exhibit in. If you want to go line by line, perhaps we can come up with a way to allow.
Yes, Your Honor, we actually only want to read from one portion of this document. So if we could actually put up that portion, would that be easier for admitting it, for purposes of admitting it?
Why don't you give me an opportunity to look at it quickly, and perhaps that will. So we're still outside the presence of the jury.
Your Honor, there is a second layer of hearsay, but I do have responses to the second layer of hearsay.
Okay.
Particularly, we're using statements from Ms. Levin that are in this document. but the statements that we're interested in from this report are being used to show that Ms. Levin changed her story to the police officer. So definitionally, those statements aren't being used for the truth of the matter asserted, rather to show that she did in fact lie. And the statements that we plan to read from the police officer himself are being offered for the effect of the listener that would be on Ms. Levin. So those are the only two parts that are hearsay within hearsay in this section of the document.
Mr. Khalfani-Bey, what's your response to that argument?
Your Honor, with no person to truly testify to the accuracy of this document, this is still hearsay within hearsay, Your Honor. There's too much going on with this document and no one to testify to break down those parts of this document for us to allow it in its entirety in, or even allow sections of it in, Your Honor.
May be heard.
No, I'm going to allow you to use this paragraph and only this paragraph. But if you are, I will still entertain objection by plaintiff's counsel as we go along. So I ask that you proceed cautiously, but we're not admitting Exhibit 21, but I will allow you to use this portion of the document during your cross-examination.
Yes, Your Honor. Now, Ms. Levin, I'd like you to read along silently as I read aloud. Levin said Levin and Jessica had not had any drinks as they were not 21. I explained that we'd likely take a blood sample from Marx. I would know if Levin was lying. I also explained that I would obtain their bar tab, which I later did and incorporate by reference herein as Exhibit 17. Levin acknowledged that Marx had a few drinks and that Levin also had a few drinks. And did I read that correctly?
You did.
We can take that down now, Ms. Clark. So, ma'am, just to be clear, when you first spoke to that police officer, you told him that you hadn't had anything to drink, right?
I did. I know it was wrong, but we were underage and I was scared. I shouldn't have done it.
So then let's talk about what actually happened. Because the truth is you were a little bit more intoxicated that night than you just admitted on direct examination.
No, that's not true.
Well, you're actually having a lot of trouble remembering what happened that night, aren't you?
I don't remember everything perfectly. It was over a year ago, but I only had 3 drinks that night.
Your Honor, permission to make use, of a demonstrative aid.
Yes.
Now, Ms. Levin, you told us the two of you had some drinks that night. But before this trial, you had to sit for a deposition, and you were asked, in what order did you and Jessica order those drinks? Isn't that right?
I was.
But you don't remember that, do you?
The exact order? No, I don't.
You claim you remember the owner talking about Ms. Marx, right?
That's right.
You remember the owner talking directly to you 8 or 9 times throughout the evening, correct?
That's right. Sonny was the one who took all of our orders.
But you were asked during your deposition how you would describe the owner's voice, weren't you?
I was.
And you don't remember that either.
I couldn't give you an exact description, no.
You were asked what the owner was wearing, right?
That's right.
But you don't remember that.
No, like I said, this was back in 2019, so I don't.
You were asked where the other customers were sitting in the bar that night, weren't you?
That's right.
But you don't remember that either.
I couldn't tell you exactly where they're sitting, no.
Objection, Your Honor. May I be heard?
You may.
Just to be clear for the record, Ms. Love just mentioned that Ms. Levin was asked where the other members of the bar were sitting. But the question she has here in her demonstrative were there other guests? Just like to point out that inaccuracy, and I'd like opposing counsel to please edit that and make sure that it accurately reflects the question that she asked this witness.
Ms. Love, are the questions in this demonstrative taken verbatim from the deposition transcript?
They are no, but we've drawn the direct ones. And now we're asking this witness directly if she remembers them here today.
Okay, well, we'll handle this constructively before closing argument. I want to make sure that if this demonstrative is supposed to be from the deposition, that it is truly verbatim from the deposition. I take Mr. Khalfani-Bey's objection into consideration, but you may proceed.
Yes, Your Honor. Now, you were asked how much you ate that night, weren't you?
I was.
You don't remember that either, do you?
I remember we had some of the chips and guac, but I don't remember an exact amount. No.
And you were asked if Jessica was swerving when she drove that night, weren't you?
That's right.
But you don't remember that either.
I don't remember seeing her swerve until she drove off the road.
And you were asked if you spoke to the police as well.
That's right.
But again, you don't remember that.
I remember speaking to them. I couldn't tell you exactly what I said, though. No.
Thank you. I have nothing further at this time, Your Honor.
Redirect?
And Your Honor, may this witness be excused?
Yes.
With that, Your Honor, the plaintiff rests its case in chief.
Thank you. Okay, witness for the defense.
Yes, Your Honor, the defense calls Sunny Mehta to the stand.
Okay. Mr. Mehta, you are sworn to tell the truth, the whole truth, and nothing but the truth.
Okay, thank you.
You may proceed.
Yes, Your Honor. Good afternoon. Could you please introduce yourself to the jury?
Hi, my name is Sunny Mehta.
What do you do for a living?
Well, nothing now, but I used to own a bar. It was called Sunny's Bar. I named it after my dad and me.
Do you know why you're here today?
I do. About 2 years ago, a girl named Jessica Marx came to my bar. She had a few drinks, and then she tried to drive home and she got into a car crash. I guess they're saying it's my fault for not realizing how drunk she was.
Okay, so given why you're here today, I want to start by talking about how you used to run your bar. Are you familiar with how to tell if someone has too much alcohol?
Sure. You know, we get trained on it every couple of years in order to keep our licenses, our liquor license. Basically, you keep a watch on the people in the bar. If they start showing certain symptoms, you know they might be a little too drunk.
As far as you're aware, what symptoms are those?
Sure. So things like red eyes, bloodshot eyes, watery eyes, you know, trouble balancing, trouble standing, lack of hand-eye coordination, slurred speech.
So then let's talk about what behavior you could actually see on the night of the crash.
Okay.
First, how often would you say that you interacted with Jessica Marx on the night that she passed away?
So that was when she would order food or drinks. So maybe 8 or so times. It was for a few seconds each time, I think.
Now, at any point, did you see her eyes looking red or watery?
No, I didn't see that.
At any point, did you see her losing her balance or having trouble standing?
No, I don't think I saw that either.
At any point, did you hear her slurring her speech?
No,
Did you hear her talking loudly?
I mean, the music was loud and she was talking over it. So she wasn't, I guess, quiet, but nothing stood out as particularly loud.
So then during the times when you saw her, how did she seem to you?
I mean, she seems fine. Obviously, she had been drinking, but nothing out of the ordinary.
Well, then I'd like to give you the chance to address some of the things we've heard in court today. Were you present in court today?
Yeah, I was.
Today, opposing counsel showed us a video of Miss Marx from that Did you see Miss Marks acting like this?
No, I never did. I'm not saying it never happened. I just wasn't there the whole evening. I was with other tables a lot of the time, so I never saw her act like this.
Sir, even if you had seen behavior like that, is that the kind of thing you believe you're supposed to cut people off for?
No. I mean, I might have done it just to be safe. She was getting a bit silly, but she wasn't showing any of those big red flags that I mentioned before.
Today we heard that she told your bartender at one point that Miss Marks needed to be cut off. Is that true?
No, that never happened.
Today we also saw some pictures of drinks that Miss Marks had, specifically Exhibit 11. Could you put up Exhibit 11, Miss Clark? I believe we're just looking for Exhibit 11 here, sir. It's the only one that's in evidence. But in that photo, the first one on there, did you see Miss Marks drinking all of those?
That one on the left? No. No, I mean, to be honest, it only looked like she had maybe 4 or 5 drinks, maybe about 1 or 2 an hour. The rest looked like they were her friend, Miss Levin, the one who was here earlier.
Objection, Your Honor, lack of foundation. I don't believe that Exhibit 11 is in evidence. To my recollection, Exhibit 14 was the only one of these photos moved into evidence.
Oh, Your Honor, that was my mistake. I'd be happy to withdraw that testimony then and refer to Exhibit 14 specifically.
Okay, so let's clean up the record a little bit.
Sure.
We are referring only to the admitted Exhibit 14.
Yes,
Is that
sure.
my, okay, Mr. Khalfani-Bey, thank you for bringing that to the court's attention.
Of course, Your Honor.
Let's move forward.
I'm sorry, Mr. Mehta, do you remember seeing Exhibit 14 rather?
Yeah, sorry about that. I've seen this.
And there's a lot of drinks in this exhibit. Did you see Miss Marks drinking all of those drinks herself?
No, I didn't.
Thank you, Miss Clark. We can take that down. So then let's turn to that friend, Miss Levin. Were you able to observe how Morgan Levin was acting that evening?
Yeah, it was pretty obvious.
How was she acting?
Well, from my experience, she was slurring her speech a bit. She was stumbling a bit at one point. I mean, I was a bit concerned, and I definitely didn't want her driving.
How was Miss Levin acting by the end of the evening?
Like I said, she was stumbling, and I actually came over and gave her the receipt, and she seemed to have some trouble with it.
Ms. Clark, could we get Exhibit 17 on the screen constructively outside the presence of the jury? What is this?
Yeah, this is one of our receipts. This was Morgan Levin's receipt that night.
Does it appear to be a fair and accurate copy of that receipt?
I believe so.
And do you keep receipts like this at the bar?
Yeah, at least a little while.
Your Honor, the defense moves Exhibit 17, excuse me, into evidence.
No objection, Your Honor. Your Honor, I believe you were muted when you just said that.
Your Honor, did you say something?
Exhibit 17 is received. Thank you.
Yes, Your Honor. Now, sir, what about this receipt made you think that Miss Levin was having trouble, like you said?
Right, so I was watching her fill it out, and if you take a look at the total line there, she did the math wrong. 119 plus 20 is 139, not 149. Normally, I wouldn't get so worked up over a math error, but I watched her do the whole thing. She just sort of sat there for a long time, just staring at it, like 60 seconds, I think, and then she wrote this down.
Thank you. Well, we can take that down now. So I just want to be clear. By the end of the evening, was it Miss Marks that you were worried about?
No, if I was concerned about anyone, it was Miss Levin.
Thank you. I have nothing further at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Mr. Mehta.
Hello, sir.
I want to talk I want to start by talking about some of your interactions with Jessica on March 24th, okay?
Sure.
You mentioned on direct examination that you interacted with her around 8 times, right?
That's right. I believe that's correct. So I took orders for their drinks about 4 times, went there and back.
I want to talk about some of the drinks you actually served them. Ms. Walsh,
Sure.
could we get Exhibit 17 up on the screen? This is the receipt that you just told us you recognize, right?
Yeah, that's right.
Now, if we could zoom into those drinks. Now, this first one, Decoy Red Blend. To be clear for the jury, that's a bottle of red wine, right?
Correct, sir. That's our decoy blend. It's a Cab and Pinot Noir.
Now, the third thing on this receipt, 3 White Claw cans. That's an alcoholic seltzer, right?
That's right, sir.
Ballast Point IPA draft, that's a beer, right?
That's right. That's one of our draft beers compared to the can.
Now, Sierra Nevada IPA can, that's another draft beer, I assume.
That's actually not a draft. It's a can.
And the last one is green tea shots, 2 of them, right?
That's right. One of our specials.
These were all the drinks that you personally served to Jessica and Morgan's table, right?
That's correct. Their table ordered these drinks and I brought them to them.
I want to talk about some drinks that you didn't bring to their table. Can we get Exhibit 14 back
okay.
up on the screen? Now, you were shown this exhibit just a moment ago, right?
That's right.
Now, this drink circled, that Ms. Wobble circled just a moment in the back. You can see that, right?
That's right.
That drink has a handle on the cup.
It does. It looks like a mason jar.
It has a straw in it, right?
That's right. It does.
And that drink has a lime in it.
That's correct.
That's very similar to a drink that you serve at your bar, isn't it?
That's right. It resembles one of our Captain and Cokes. It's rum and Coke.
To be clear for the jury, you never served rum and Coke to Jessica and Morgan's table, did you?
That's correct. They never ordered it with me. You're right.
But they had a drink that you served at their table, right?
I'm not sure that they had a drink that looked like one of our drinks. That's right.
All right. Now, I want to talk a little bit about the symptoms you told us you didn't see or did see with Jessica that evening, okay?
Okay.
Ms. Wald, could we get Exhibit 10 up on the screen? Mr. Metter, you were shown that you've been in trial all day today, right?
Yeah, that's right.
So you saw this video earlier.
Right. I did.
You'd agree with me that this video looks like it was taken in your bar, right?
That's right. That's one of our tables. Those are our drinks.
And you recognize that's Jessica, right? Jessica Marx right there sitting there, yeah?
Yeah, that's Jessica.
Jessica was only in your bar, to your knowledge, on March 24th, 2019, right?
That's correct, sir.
And you've been sitting in court, like I mentioned.
Again, I have. That's right.
So you saw this video.
Yes, I did.
On direct examination, you told us that you might not cut someone off who looked like this, right?
That's right. Again, she was acting a little silly, but I didn't hear her really slurring her speech. Didn't see her eyes. Didn't see her particularly loud. That's right.
Ms. Wald, can we play the video?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or
Pause it for a
an
second.
actress. I like.
Mr. Mehta, you said that she didn't sound like she was slurring her speech in this video.
Not too much, sir.
You don't think she sounds drunk in this video?
Sure, she certainly sounds a little drunk, but again, not to, I would say, our cutoff point.
You wouldn't say she's obviously intoxicated in this video?
I'm not sure. Again, she seems a little drunk, but again, I wouldn't put her at the cutoff point.
Can we play a little bit more, Ms. Well?
To thank the Academy, Mom and Dad.
Pause it right there, Ms. Well.
Inspired me.
You'd agree with me that her glasses are on crooked here, right?
Yes, sir, they are.
She seems a bit disoriented, yes?
I suppose so. That's right.
You don't think she looks obviously intoxicated here?
Again, sir, I couldn't say.
Let's play a little bit more, Ms. Wild.
Okay, well, Go big or go home.
You saw her there at the end try to reach for a can, right?
That's right.
It looked like she missed it the first time. Do I have that right?
Yeah. She went for a different bottle and then grabbed the can.
You don't think she looks uncoordinated in this video?
Sure, she looks a bit uncoordinated.
You don't think she looks obviously intoxicated?
Again, sir, I couldn't say.
So if someone like this were to come into your bar, you might still serve them alcohol.
Sure, like I said, again, she seems a bit drunk, but I wouldn't put her at the cutoff point.
Your Honor, I have no further questions.
Brief redirect, Your Honor.
Okay.
So I'm going to ask you a few more questions about that video. Now,
Okay.
just to be clear, where were you when that video was filmed? Were you on the patio?
I'm honestly not sure. Could have been serving drinks. All I know is that I didn't see that.
Did you ever see her acting like she was in that video when you were there that night?
No, I didn't.
Thank you. I have nothing further, Your Honor.
Okay. May this witness be excused?
Yes, Your Honor. At this point, the defense rests its case in chief.
Okay. I assume, counsel, you're ready for closing argument?
Yes, Your Honor.
Yes, Your Honor.
Ms. Love, do you intend to use the demonstrative with the deposition transcript in your closing?
I do, Your Honor.
Okay. Mr. Khalfani-Bey, remind me, please, what the issue was. I think you were concerned that there was a question in there that was not taken directly from the deposition transcript. Is that right?
Well, Your Honor, my issue specifically was there was a question written here on the document, but Ms. Love asked the witness a different question. The question on the demonstrative said, were there any people at the bar? She asked the witness, could you tell them where the people were at the bar? It's slightly different, but I just want to make sure it's clear for the record.
Okay. I appreciate that. I believe that the record has been made. Ms. Love, go ahead and use that demonstrative. And Mr. Khalfani-Bey, you can also use your demonstrative. So without any further ado, we are now going to hear closing arguments from each party. Everyone should please switch back to speaker view. And since both witnesses have completed their testimony, scorers, you can now complete the witness portion of your ballot. You may proceed.
Actually, Your Honor, one further thing before I begin my closing argument, just to show Ms. Love the demonstrative, and Ms. Wild, if we have it ready, I just wanted to make sure that she sees the demonstrative, that the title has been redacted before I begin my closing argument, just so that Ms. Love has seen it.
Okay, we appreciate your professional courtesy. Okay, thank you.
Does that work?
Your Honor.
All right.
Okay, anything further before we commence closing?
Nothing further, Your Honor. We're ready to proceed.
You may proceed.
Opposing counsel, members of the jury, may it please the court. Bruised ribs, a lacerated liver, fractures to her skull, bruises all over her body. Those are injuries we saw from her autopsy. These are injuries that could have been prevented if the defendant had just used common sense. We're here today suing the defendant for the death of Jessica Marx. We had to show today that the defendant sold Jessica alcohol when she looked obviously intoxicated, and we showed just that today. Because we showed that it was just common sense that she was drunk. Now, we talked a lot about how much alcohol Jessica had to drink that night. We went through each drink she had. Can we get it up on the screen, Ms. Wild? Now, we heard today that she had 2 glasses of wine, almost a full bottle of wine, an unknown beverage that resembled very closely to a rum and coke that the defendant's bar serves. But the defendant said that they didn't serve that. We know that Jessica had 3 alcoholic seltzers, a beer, and a shot. All this alcohol. Keep in mind that the defendant was just 19 years old. She only weighed 115 pounds. She was only 5 feet tall. And the defendant served alcohol after alcohol, glass after glass that evening. It's just common sense that someone that small would get drunk from this amount of alcohol. And we also showed you the receipt for how much they had. And remember that drink. That wasn't on the receipt. So we know that there's at least one drink that Jessica had that evening that wasn't on the receipt, but how many more? We heard today that Jessica went into the bar, came back out with the drink, but that she didn't order it from the defendant. So are there other places at this bar where you can get drinks that the defendant doesn't know? How much more drunk was Jessica that night than we know? Well, we can look at her symptoms. We heard a lot about her symptoms today. Could we get the chart up on the screen? Morgan Levin told us that she had impaired judgment. She chose to drink and drive. That she had alcoholic breath, incoherence, slurred speech, poor coordination, loss of balance. Members of the jury, when you go back to deliberate today, you're going to get a form to fill out. It's called your jury deliberation form. And on that form, it'll have a list of symptoms that are the symptoms that you could consider when wondering whether or not Jessica was obviously intoxicated that evening. You'll find that the list we have here matches it almost exactly. She exhibited all these symptoms that night, but the defendant just wants you to believe he didn't see them. And he went back and forth to that table 8 times, but didn't see any of those symptoms. I played the defendant the video today. He said he didn't see it. He said at no point in time when he saw Jessica that evening, she looked like that. But he went back and forth to that table 8 times. But what's really interesting is that the defendant told you that he'd served someone who looked like Jessica alcohol again. We saw how drunk she was. We saw her slurred speech in the video. Ms. Wild, you can take that down. We saw her being uncoordinated, reaching for the wrong glass. Her glasses were tilted. And the defendant said he would serve someone like that alcohol again. That's someone who doesn't understand the gravity of what they've done. That's someone who's a danger, someone who we need to hold responsible. Now today, it was just common sense. We saw it. Jessica was drunk that night. We know from how much she drank. We know from her symptoms. It's just common sense, like it was just common sense that she was drunk in that video. The defendant wants to deny common sense. You know that they were drunk, members of the jury. The defendant knew too. Find the defendant liable for Jessica's death. Thank you.
Okay, closing by the defense.
Yes, Your Honor. Before I begin, can you see and hear me okay? Oh, you should be able to see me now.
Yes.
May I please the court? At the beginning of today's trial, my co-counsel, Ms. Clark, turned on her screen to say good afternoon, and none of us have seen her on screen since then. Now, if she had 5 drinks during that time, then no one on this call would be able to tell. If she was acting so drunk that someone needed to cut her off, well, none of us would have any idea. You just wouldn't know because you haven't seen her. That's exactly what happened in this case. You see, no employee of Sunny's bar actually saw Miss Marks acting drunk. They didn't see her stumble or slur any more than we've seen Ms. Clark do those things. This case isn't about common sense. It's about what they could and could not see. Because members of the jury, you can't control what you can't see. Now, I want to take a moment and talk a bit about the law in this case, because it's important you know what you're actually going to have to decide. You see, today the plaintiff has the burden of showing you that it was more likely than not that Sunny's bar served Jessica Marks alcohol while she was obviously intoxicated. And they have not met that burden. But even if you believe they had met their burden, you'll also have to consider whether we've met ours, because we have raised what's called an affirmative defense in this case, which means we had to show you that Jessica Marx's actions were a substantial factor in her own death. And to do that, all we had to do was show you that she made a decision on her own to drink and then to drive, and that decision caused her death. And so members of the jury, what this whole case really just comes down to was whether she was obviously intoxicated and the bar should have cut her off, whether this was just her own bad decision. So to answer those questions, I want to take you back to the 3 questions that I asked you at the beginning of this trial. First, can you actually trust the plaintiff's story? Second, what behavior did the staff actually see? And third, how many drinks did Jessica Marx actually have? Let's start with whether you can trust the plaintiff's story. You see, the plaintiff's entire case revolves around the testimony of Morgan Lett, Jessica Marx's best friend. But today you heard about some things that might have affected Miss Levin's testimony. You heard how Miss Levin has a lot on the line today. That when she first gave her deposition, she knew there's a chance that she might be sued herself. And then you heard how she has no problem lying to protect herself. You heard how right after her friend crashed, when the police were just trying to find out what happened and asked her some questions, Miss Levin didn't tell them everything she knew to try and help. Instead, Miss Levin lied. She claimed that neither she nor Miss Marx had been drinking at all that night. That's what she does when she wants to protect herself. And that's why her testimony cannot be trusted. So then that brings me to that second thing we showed you. What behavior did the staff at Sonny's bar actually see? Now, you heard from Mr. Mehta today how he never thought Jessica seemed obviously intoxicated that night. Now, the plaintiff is trying to claim that's wrong, but let's walk through the evidence they actually showed you. Now, opposing counsel showed you a video of Jessica Marx in which she might have been drunk, and he claimed that was all the proof he needed. But you heard from the plaintiff's own witness how none of the staff at Sonny's bar was actually there when that video that they talked so much about was filmed. And then Mr. Mehta told you he wasn't there. They couldn't see it. They couldn't control that. And even more than that, you heard how we don't actually know exactly where anyone in the bar was when that video was taken. Ms. Marx could have sobered up quite a bit before she left the bar. And that's what matters. Because this video doesn't show us anything about what Miss Marx looked like to staff when she left. And you can't control what you can't see. So then we get to that third thing. How many drinks did Jessica Marx actually have? Now, the plaintiff wants you to believe she had so much to drink that anyone could tell she was obviously intoxicated. Opposing counsel just got up here and with absolute certainty listed off, showed you a whole demonstrative of different drinks that Miss Marx had. But let's consider whether we can really be so sure about that. You see, the bar was serving 2 people on that evening, both Miss Marx and Miss Levin. And Miss Levin wants you to believe that all those drinks, well, those were for Miss Marx. But by all accounts except her own, Miss Levin had more to drink than her friend. You heard from the owner of that bar that Miss Levin seemed far drunker than Miss Marx on that night. So then maybe you're wondering, how do we know who to believe? Because Miss Levin says Miss Marx was the drunk one, and Miss Mehta says that Miss Levin was. Well, unlike the plaintiff, we brought you proof. Because I got up and I asked Miss Levin about what she remembered that happened on that night. And time again, she told you that she just doesn't remember. She doesn't remember who ordered the drinks. She doesn't remember what she told the police. She doesn't even remember how her best friend was driving before she swerved off the road. Why? Because Miss Levin was drunk that night. Miss Levin was drunk because she'd had the drinks on that table, which means there were far fewer drinks left for Jessica Marx. The plaintiff's whole case rests on the idea that Jessica Marx drank so much that no one could confuse her for sober. But what you actually heard today is Nobody knows exactly how she had to drink. It's absolutely tragic that Jessica Marx lost her life at such a young age. The tragedy in all of this doesn't change what happened. It doesn't change the fact that only Miss Marx knew how drunk she was, and only she made the choice to get into that car and endanger her own life and the lives of others. It doesn't change the fact the staff at Sunny's bar didn't know how drunk she was when she left that bar. You can't control what you can't see. That's why we ask that you find Sunny's rooftop bar liable, or not liable, excuse me. Thank you.
Rebuttal?
Yes, Your Honor, may I proceed?
You may.
The defense just came before you and wants you to believe that Sunny Meta is the most oblivious owner there is. That Jessica was exhibiting these symptoms, but that he didn't see any. That there were other drinks being served to Jessica and Morgan that night, but that he didn't see them. Even though he was back and forth at that table 8 times. You see, we had to show today that Jessica was obviously intoxicated that night. We didn't have to show that the defendant had his eyes open to see it. The defense also wants to come up here and blame the victim. They want you to think that it was Jessica's fault that she died that night. But you see, when it comes down to it, the defendant took away Jessica's choice when he didn't cut her off that night. When he didn't use his common sense and see that she was drunk. When he didn't look at the amount of alcohol he was serving their table and see she was drunk. She needed to be cut off and the defendant didn't do it. Find him liable. Thank you.
All right. Thank you so much. Judges, please complete your ballots and click submit, and then I'll ask everyone to stay on until everyone has submitted their ballots, and then we're going to do brief comments.